Well, let's unpack this now, and in particular, South Africa's latest application to the ICJ. We're joined by the University of Johannesburg's international law professor, Hennie Strydom, who talks to us from the Western Cape. Professor, good evening to you, and thank you for your time. 20 children have died, and you would have heard the president there of South Africa saying that this is now as a direct result of starvation. Using food as a weapon of war, is it still a point to argue that Israel is indeed using food as a weapon of war right now?
Yeah, good evening. It's quite clear that South Africa is now, with this third application, shifted its focus to the humanitarian conditions, and in particular the famine that is unfolding and the effect that has on, especially on children. There's a very sort of striking statement made by South Africa, and it said that that is no longer a risk that might happen. It is already happening. And I think it's that sort of approach to the whole incident now unfolding in Rafah and other parts of Gaza that South Africa is using to say to the court, listen, this whole humanitarian crisis has come to a point where it is now necessary for the court to provide for additional measures. We have to remember that in February, South Africa made a second bid at getting additional measures that was unsuccessful. Of course, the court said that the situation at that time hasn't sort of changed much compared to what was the situation in the first round of applications South Africa lodged with the court. But now the situation, as far as the humanitarian situation is concerned, has become incomprehensible. And certainly the developments now are such that the court is now urgently needed to make or to consider and direct additional measures.
Yeah. Professor, we placing emphasis here that this is the third letter that is being written by South Africa to the ICJ. We're going to talk a little later about the point that I think South Africa is trying to make here. But I'm sorry to use this language, but we're going to have to at some point. The second letter, is it fair to say that South Africa was fobbed off by the court because it was very clear what South Africa was complaining about, and that is to say Israel is not complying. We need your immediate intervention. And again, as I repeat the use of the word fobbed off, is that a fair characterization?
Yeah, indeed. It is quite clear that Israel has no interest in complying with the orders of the court. And it places the court in a very difficult situation because it doesn't have enforcement powers. It places the responsibility on the international community to do something more drastically to bring to an end this conflict. But the primary responsibility rests with the parties to the conflict. And in this latest application by South Africa, it has clearly stated that the parties to the conflict must bring to an end this conflict and allow humanitarian aid to get through, etc., etc. And that is the point I want to make. The court doesn't have the power to stop this conflict. The primary responsibility rests with the parties to the conflict and with the international community. And I think that is what we have to understand concerning the enforceability of the orders that the court is required to make.
If that's the case, Professor, I'm sorry to interrupt you. If that's the case, then why does South Africa keep going back to the ICJ? What point are they trying to make, if any?
I think they're trying to bring across the sort of responsibility on the international community to do something about it. Because every time the ICJ decides to grant the order and to make an announcement on that and to assess the situation and justify the sort of the reasons for interim measures, etc., it places a more serious and I think urgent obligation on the international community to do something about it. Now, that is our hope. I think it's our last hope at this point in time that international pressure will bring this conflict to an end, because the court cannot do it. It doesn't have the power to enforce its interim measures. And I think by building up the sort of the intervention by the court, South Africa is hoping to bring about a situation where the international community is in a situation where it will have to respond more drastically with an intervention to bring this to an end. One of the applications that South Africa, again, made clear in this application is that there's a responsibility on other states not to contribute to this conflict in any way by providing weapons or other forms of assistance, facilitating Israel to proceed with this military campaign. And I think that is one of the important issues that South Africa would like to get across to countries like the United States and others, to realize that if they participate in this, they are contributing to the atrocities that are being committed by Israel currently.
Well,
and I think that is the only option left for South Africa at this point in time.
Well, it is the United States that you invoke now, and that's the point perhaps, or the last question I'm going to ask you. We have heard from them recently quite literally calling for a ceasefire. The Vice President of the United States, Kamala Harris, making an impassioned plea. Is it the point now where the Security Council, the United Nations Security Council, once again convenes, and on the table is a motion, or is, I forget the term that is used there, but it's basically to consider a ceasefire, place it back on the table, because it has been countries like the US who have stood against and vetoed the multiple ceasefire drafts that have been put forward. Is that where this goes back to right now?
Yeah, that's a good point you're making. If it comes from the U.S. administration, the call that you're talking about for a ceasefire, if it is now placed on the agenda of the Security Council, they will have to show their cards on that. So they can't call for it from the administration point of view, and then when it comes to the Security Council, then veto it. So that would be sort of incomprehensible. So maybe we are moving towards that direction, and hopefully, well, we must understand the United States is not the only country that can veto it. But it's probably in the most sort of, strongest position to take that stance, given its record up until now.
Yeah.
So but you're quite right. We are moving into that direction where the Security Council may be in a totally different position when there's a call from the United States for a ceasefire.
Professor Hennie Strydom, thank you very much for your time and input on this matter. He's from the University of Johannesburg, the Faculty of International Law.